some of them look down. Me I read the comments them. Not some of them there.
To promote observance of human rights.
Again.
Oh. Babylon, go down, dirty Babylon. Dirty Babylon, go down, dirty Babylon. Some face, all of the people that went to Gaza. How tell you what we say? Babylon say. Let the judge say bail for me. Somebody tell the jury. Oh, Father, say no.
Me not done a question and answer over here. In no business.
Dirty like rubbish truck. Me just a pre-back happy days memories. When me kids, when me wife, when me Benzes.
In the Charter. And it's part of the context in which admissibility questions should be viewed.
Viewers and subscribers, welcome back to another update. So Vybz Kartel's ex Shorty dodged questions about Vybz Kartel Privy Council appeal. You know, she was recently on a TikTok live and fans basically a comment and ask her how do she feel about the big day tomorrow, which is the 14th and the 15th also. So it's like Shorty I say a people business that. So everybody knows that she wasn't gonna answer those questions because, you know, Vybz Kartel obviously move on and, you know, I deal with a different woman. So I'm gonna show you the full video in relation to that. Also in this update, you know, I'm gonna show you the full live proceedings of Vybz Kartel Privy Council hearing, you know, basically the courtroom settings and the whole proceeding. Because everybody wants the Vybz Kartel free at this point. You know, them will go over the evidence and, you know, the judge are going to decide whether or not them throw out the case or them do a retrial. So this is basically the live courtroom proceedings. So viewers and subscribers, before we get into all these updates, please remember to leave a like on this video, very important. Also subscribe to the channel if you haven't subscribed as yet, and leave your thoughts down in the comment section.
Listen. You can't get pump from a prison. And next man have your girl when you're missing.
Oh my them look. What is it? Me which one of them said some of them look down. Me I read the comments them. Not some of them there. I'm not gonna say so I read them. Go and tap up the screen there, guys. We could go and talk. No negativity over here. Them love the black. Trade you with the roses. Valentine's Day roses. Get my Valentine's rose I heard on Can't Talk to me. Big up for the rose them. Me not done a question and answer over here. J-Doll. It's not a question and answer, okay? Chop. No, not no limited. No limited. Just see worse. Like come here drink, you look at anything now. You know how that go? Yes, guy, how it go? Take all a shot right now. No business, sir. Even fast on a different level. Torment to kill them. Tormented with true man. Them never christen. You have to know if you clean this blood clot, yeah. So, Prince, pin that no? Come, me now see how me do it. That used to be you. Friend can be merry.
So viewers, it's like Shorty is not showing any remorse towards Kartel freedom. You know, we don't know if she happy or she sad. Yo, she really no business about it because, you know, Vybz Kartel move on with this white girl called Sidem Osterk, and him basically pour out him art all the time on social media over this female. And him basically this Shorty the other day when Russian dropped the Go-Go Club rhythm, which is now the Dirty Money rhythm, and you know Vybz Kartel put a song on the rhythm when he must say, yo, him run with the short girl and them thing there. So I guess, you know, Shorty must feel away and it kinda look bad upon her because them a come from far. But you know, you the viewers can tell me what you think about this. Leave it in the comment section. So now viewers and subscribers, Vybz Kartel case will be heard today, you know, February 14th, and tomorrow, which is the 15th, you know, at the Privy Council in England, you know, live courtroom proceedings. We have a video in relation to that, so we are going to play the video and you guys can watch out the full video to get a better understanding of how the case is going and if Vybz Kartel are going to get off this case. You know, I think Isaac Buchanan is there in England to represent Vybz Kartel, and you know the whole thing surround tampered cell phone evidence. So you know, if that is considered, I guess them are going to do a retrial or so, or them just throw the case and allow Vybz Kartel to walk free. So I'm going to play the full courtroom proceedings and you guys just watch to the end. Don't forget to leave a like on this video.
Section 13(1)(a) imposes a positive duty on the state to promote observance of human rights. Now that is, in our submission, a demanding standard, and it's not. It goes beyond a mere obligation to comply with the human rights standards contained in the Charter. And it's part of the context in which admissibility questions should be viewed. Obviously, a key way of promoting observance with human rights is to ensure that non-compliance with the Charter has consequences. 13(1)(c) I draw attention to because it demonstrates, and there are other features of the Charter that reflect this, the fact that Jamaica's approach to human rights goes beyond, in one sense, a European approach because it applies to all persons. The obligations under the Charter apply to all people. That was, looking at the debates, a positive decision, and it demonstrates a key feature, and I'll take you to some material that makes good this submission, of the Charter, which is a desire essentially to enhance rights, reflecting the fact of Jamaica's independence.
Yeah, man, that looks stressed out.
Section 13(2) then indicates that effectively the rights that follow in Section 13 have to be complied with, save as may be demonstrably justified in a free and democratic society.
I know, bro.
Subsection B makes it clear that no organ of the state shall take action which abrogates, abridges, or infringes those rights. So that's important for a couple of reasons we would submit. Firstly, it makes it clear that there is an obligation on the courts, because as an organ of the state, essentially, to ensure that those rights, the rights that are incorporated within the Charter, are not abridged. Secondly, when read then with subsection 3J Roman 3, which is about the privacy of communications, it explains why in our submission it is clear that a failure to comply with the relevant legislation, the Interception Communications Act, is a breach of the Charter. And the reason, quite simply, is the legislature has decided effectively the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's the domestic law effectively to fill in the gaps, and that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy, and that's why it's so important, compliance with it, and that's why in our submission it is right to it's right that the courts below proceeded on the basis that there was an interference with the right to privacy. Now, one thing I should just touch upon is that the prosecution say, well, it's absurd, I think is their language, to argue that the constitutional rights of Mr. Chow or the deceased or his girlfriend were interfered with. In our submission, firstly, the approach to waiver will become clear when I come to jury rights, and in our submission there's no suggestion of waiver. But in any event, it misses the point. The whole point about the Interception of Communications Act is that in a modern society, clearly there is a huge amount of data held on all of us by people like communications companies. So there is a need for safeguards because there's no reason to believe that the material obtained was necessarily restricted to the deceased, his girlfriend, or Mr. Chow. All the indications are indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly just so I can avoid going back to them. Firstly, section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G, is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we made this clear in our written statement of case, there are issues that potentially arise if the state breaches constitutional rights. There are fair trial issues, not least because, in one sense, the state then has an inequality of arms. It is used the powers it has in an unlawful way. The other provision we draw attention to, because it was touched upon by the trial judge sort of indirectly, is if you go to section 19.4, section 19 is essentially concerned with redress. And in particular, section 19.4 recognises that although the Supreme Court has jurisdiction generally to deal with breaches of the Charter, a point the judge made, there is a need, because redress has to be effective, for other courts potentially to exercise their jurisdiction. That would submit to the Brandt case, which we've referred to in our statement of case, which indicates it could be an abusive process, essentially, to go to a court like the Supreme Court in the course of criminal proceedings. And we would say that the more fundamental point is that we can make about Section 19.4 is it demonstrates the importance of redress being effective, and that, in our submission, is part of the reason why it's important that in appropriate cases evidence obtained in breach of the Charter is excluded. The Charter itself is, just to be clear, an unusual provision within the Caribbean, in the sense that, and this is recorded in a book that we've included in the authorities, page 8334, the Oxford Handbook of Caribbean Constitutions, is that Jamaica is one of only 3 countries that has made significant changes to its independence constitution. In Trinidad, they're described as being cosmetic. In Guyana, they were concerned with the presidency being introduced. But in Jamaica, obviously, they were focused on human rights, and that's important. Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in 2 ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions, and that's partly why we submit we're entitled, for example, to refer to the Irish Constitution, because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in that sense, one of the recommendations of the committee, which was adopted when the legislation passed through the Jamaican Parliament, it is set out at 8211, and that is that there should be a limited preamble reflecting the historic background, essentially, to the legislation, but most importantly, making it clear that what the legislation, the Charter was intended to do was produce, and I use these words because they're found in the preamble, was produce more comprehensive and effective protection of fundamental rights. So the clear intention of the Jamaican legislature when adopting the Charter was to enhance human rights. And that's reflected, I think, given time, I'm not going to take you to it, but we would refer you to the judgment of the Chief Justice of Jamaica in the Robinson case, first instance, but it is a judgment of the Chief Justice reviewing the significance of the adoption of the Charter, and that's particularly paragraph 203. Sorry, it's page, I should have given you the page. It's 6472, particularly, in fact, paragraph 6475N. And so there has been reference, it's not my term that I came up with, as to how the Charter is a Jamaicanized version of human rights, or it's a Jamaicanized approach to human rights. That's the context in which one should look at Muhammad. And Muhammad is in one sense, perhaps the least we ask for, or the least we argue for. In our submission, it reflects the current approach of this court to written constitutions. Now, Muhammad starts at 6301. And it was concerned with a breach. You see at para 11, it was concerned with a breach of constitutional rights resulting from the admission of a statement. Now, my learned friend says, essentially, just to address one point, that there is a difference, because what happened was in Mohammed was a breach of an express provision in the Constitution. He suggests there's a distinction here, but in our submission, nothing in this judgment indicates that there are different types of rights protected by written constitutions. The fact of the matter is, either there was a breach of the Constitution here or there wasn't. And as the question is, as the issue is identified at paragraph 11, the issue in Mohammed was the consequences. And the approach of the Court of Appeal, having rejected an argument based on US case law, essentially, that there was an absolute exclusion. The approach of the Privy Council, essentially, having reviewed a number of other judgments of a number of other courts considering written constitutions, is at 28 and 29 of the judgment, which is 6308. Couple of points that, well, just to highlight a few things. Firstly, and it's important given the facts of this case not to lose sight of this, at the top half of paragraph 28, the court makes it clear that if there's a dispute about facts, the burden is on the prosecution, essentially. And that, it was said to expressly include, for example, whether there was deliberate infringement of the rights. And that's important in our submission. Firstly, it clearly reflects the criminal standard of proof, but it does in our submission demonstrate in a case like this that if the Crown is going to say, for example, we could have obtained this material in any event, it needs to demonstrate that by evidence, essentially, as to from the relevant designated people. It also needs to explain what happened in relation to leadership in this case. Now, in terms of the test to be applied, the court notes, and I accept it expressly says this is in the context of Trinidad and Tobago, and that's important in one sense because obviously each constitution will have its own features, and as I've already indicated, Jamaica has this unusual feature of having adopted a deliberate, having rejected or amended the independent constitution and replaced that with a constitution which was intended to reflect a lengthy debate that had taken place within Jamaica. But it said in the context of Trinidad and Tobago, the approach is neither prima facie exclusionary nor prima facie inclusionary, but there is a need to weigh the interests of the community against the interest of the individual who's been exposed to an illegal invasion of their rights. Now, that is the context of then what follows in paragraph 29, and paragraph 29 is quite clearly a rejection of the King approach on the basis that there was a distinction to be drawn between constitutional rights and common law rights. And the reason it does that is because it indicates that it's of fundamental importance that a right is important enough to be contained within the Constitution, and constitutionality has to be given meaning.